TNER. I represent Legislative District 2, and I'm here to introduce Legislative Bill 612. Legislative Bill 612 amends Section 28-1409 to strengthen Nebraska self-defense laws. Section 28-1409 is a statute that delineates the conditions that must be present when force or deadly force may be used and considered justifiable under law. Currently, this section of Nebraska self-defense statutes also requires that in certain circumstances, a person must retreat from using force outside the home or business. LB 612 amends this section of law to strengthen and clarify when the use of deadly force is justifiable and when it's not justifiable. Moreover, it removes some requirements for a person to retreat when outside the home or place of employment. Specifically, LB 612 recognizes subsection 4 that deals with when deadly force is justifiable and when it's not justifiable. On pages 2, line 26 and 27, LB 612 adds the felony crimes of robbery, arson, and burglary to the current list of death, serious bodily harm, kidnapping, and sexual intercourse compelled by force in which deadly force may be justifiable. These justifications in subdivision 4A1 could happen outside the home, place of employment, or an occupied vehicle, while the next two subdivisions are confined to those locations. After reviewing the bill further, I would defer to committee on whether they believe burglary on line 27 is essentially covered in subdivision 2. We have an amendment that would strike burglary. The next subdivision deals with when deadly force is justifiable within a dwelling, a place of business, or an occupied vehicle. It's come to my attention after review, the subdivision 4A2 may go beyond my intent and may allow a business owner to shoot a person sleeping in a business warehouse that wasn't a threat. Clearly not what this bill had in mind. So I believe that oversight could be addressed in several ways. We didn't have time to draft a thorough amendment for this hearing. Moving to subdivision 4A3, it deals with essentially kidnapping within the location of a dwelling, place of employment, or occupied vehicle. Subdivision 4 on page 3, lines 8 through 10, or sort of a catch-all provision that I believe would be overly broad and problematic. I have AM 577 that would strike that subdivision. You have that in your hand. Next, on page 3, starting on line 11, LB 612 describes when deadly force is not justifiable. If you look on page 4, this is where the bill removes the obligation to retreat in most circumstances. Finally, the bill allows for the actor to be wrong in their estimation of danger as long as there is a responsible basis for the belief and they act reasonably in their response. I believe 6112 is a good start, giving Nebraska residents a strong self-protection law that will be easier for them to understand. I will try and answer any questions at this time. Thank you for your consideration.
Senator Chambers.
Senator Kentner, I have only one suggestion. When you spell your name, allow a break, because I was just listening to you spell it, and you said B-I-L-L-K. That spells bilk, and that's not what you mean. That's my only suggestion. Break those two apart when you're spelling it.
Thank you, Senator.
You're welcome. That's all that I have.
See nothing further? Are you going to stay for
Yes, I will.
closing? Okay. First proponent. Proponent?
Good afternoon, Senator Seiler, members of the Judiciary Committee. My name is Kent Rogert, K-E-N-T-R-O-G-E-R-T, and I'm here today on behalf of the National Rifle Association in support of LB 612. We thank Senator Kintner for bringing it. It's our policy to support bills that outline the concept in this bill, which strengthen self-defense statutes in all states. I'll answer any questions.
Any questions? Seeing none, thank you. Next proponent. Seeing none, first opponent.
My name is Amanda Gailey, A-M-A-N-D-A-G-A-I-L-E-Y. I am speaking against this bill as the representative of Nebraskans Against Gun Violence. Killing another person should be a last resort. Stand your ground inscribes into the law that killing another person need not be a last resort. The American Bar Association conducted a study of the effects of stand your ground laws. They found that stand your ground is associated with no decrease in burglary or assault and an increase in homicide. So on a practical level, stand your ground does not work as a measure to reduce crime. In fact, the study recommends that states seeking to reduce crime not enact stand your ground legislation, and I hope we can count Nebraska among states seeking to reduce crime. Further, the American Bar Association discovered that stand your ground is not applied consistently and results in racial disparities. Even before a stand your ground case gets to a courtroom, the racial disparity of the law is at play. Black people are viewed with more suspicion in public places than are white people. In fact, studies have shown that racial bias can cause people to think a black person is holding a weapon when he is not. Stand your ground empowers biased people in public places to kill someone they believe to be a threat, even when safe retreat is an option. In this way, stand your ground emboldens gun carriers and sanctions a vigilante attitude that will necessarily have an oppressive effect on black citizens who know that they are viewed with heightened suspicion and must worry that any misinterpretation of their behavior could result in their authorized murder. American gun culture has grown increasingly virulent in recent years, and it stokes vigilantism by telling gun extremists, quote, "It is better to be judged by 12 than carried by 6, unquote, which is another way of saying, when in doubt, kill first and let the jury sort it out later. I'd like to make it very clear that the extremism and racialized violence we are talking about here is not an abstraction. A stand your ground law in Nebraska will be interpreted by paranoid armed people in our state as an authorization to use lethal force when none is warranted. In a recent exchange in an online forum for fans of the Nebraska Firearm Owners Association, someone asked what the legal penalty would be for carrying an unlicensed gun in his car in Omaha. Another Nebraska resident responded that the penalty for not having a gun in Omaha, quote, would be death by hood rat, unquote. As the racially loaded language conveys, some people in our state go into public anticipating the need to shoot black people. Bill Kintner would like to tell them to go ahead. He's got the jury covered. I'm happy to answer questions if anybody has any.
Any questions? Seeing none, thank you for your testimony.
Thank you.
Next opponent.
Hi, my name is Melody Vaccaro, M-E-L-O-D-Y, V-A-C-C-A-R-O. I'm a graduate from Papillion La Vista High School in Senator Kintner's district. My family still lives in Papillion. This law will mean a death sentence in lieu of a trial for many, but especially for African Americans. If this bill is passed, people of color will be shot and killed in higher numbers. According to research put out by the Urban League, the number of legally justifiable killings after stand your ground laws are passed more than doubles. For that same period of time, in states who have not enacted a stand your ground law, the legally justifiable homicide number actually drops. The following words have been taken from the end of a news story from NPR about a 17-year-old black child named Jesse Washington. His public murder was legally justifiable back in 1916. His punishment did not fit his perceived crime and caused an uproar about injustice across the nation. I've inserted the name of another unarmed 17-year-old black child who was legally murdered 3 years ago, with the anniversary being yesterday. His crime was looking too scary and walking past a scared man in a car who had a gun and the law on his side. Trayvon Martin's killer still owns a gun and has since had multiple interactions with police due to his violent behavior. Trayvon Martin's legally justifiable murder has caused a national uproar of injustice across the nation. And here's an altered quote from that story. The methods used by the justice system of the time also encourages endless speculation about Trayvon Martin's guilt or innocence. In that poisoned climate, it would have been up to Trayvon Martin to prove he was innocent. And Trayvon only had the dimmest understanding of what was going on. For the purposes of this story, however, it makes little difference in the end whether Trayvon Martin was innocent or guilty. Nothing he could have done would have justified what happened to him. Nebraska already protects those who kill in self-defense, as it should. The data shows that if passed, there will be more Nebraskans legally murdered. This bill does not protect anyone, but in fact endangers us all, and especially those who are not white. I am against LB 612.
Any questions? Thank you very much for coming.
Thank you.
Next opponent.
My name is Courtney Lawton, Courtney Lawton, Senators and Honorable Chair. I come before you opposed to LB 612, the Stand Your Ground law. Do I need a gun? I ask myself this when Stand Your Ground becomes the model for what we do when we are scared or intimidated or nervous or angry. I can only predict two things: the proliferation of guns and escalating violence where rule of law is quickly eroded. In an American Bar Association study of Stand Your Ground cases in Florida, 60% of people claiming they had to stand their ground had been arrested previously. 1 in 3 of the shooters had previous arrests for violent offenses. Of course, criminal defense lawyers use the claim of Stand Your Ground more and more. The ABA study found an assertion of Stand Your Ground resulted in 0 criminal liability in 70% of the cases. How long until the dangerous, trigger-happy men and women who walk among us realize that with only one alive to tell the story, reasonable belief that there may have been a threat becomes an unavoidable conclusion that there was a threat? Do I need a gun? We know criminals get guns and commit violent crimes. Violent offenders are already using Stand Your Ground to justify their criminality. What we don't know is at what point will the rest of us begin to rationalize shooting someone dead as an acceptable response to our problems. For nearly 40 years, the answer to the question, do I need a gun, has been an unequivocal no. Because I live in America, a nation with a judicial system, both criminal and civil, where the criminals face trial and conviction, I do not live in a war-torn, failed nation state where personal safety is in the hands of warlords and mercenary armies. I do not live in a cartel-ridden country where a corrupt government protects the criminals and not its law-abiding citizens. Please, respect Nebraska. Honor our legislative and judicial bodies as they do the work our nation's founders set before them. Do not turn our streets into vigilante battlegrounds where violent offenders know full well and good that as long as there is no one left alive to dispute their use of deadly force, they are free to subvert justice and act as self-appointed judge, jury, and executioner. Thank you.
Any questions? Thank you for your testimony. Next opponent.
My name is Danielle Savington. That's DANIELLE Savington. Senators and Honorable Chair, I am a resident of Papillion, the 2nd District of Nebraska. I am also a criminal defense attorney and juvenile court attorney. I come to you today opposed to LB 612, the Stand Your Ground law. Stand Your Ground is an expensive solution to a problem that Nebraska does not have. Senator Kintner would tell us that the estimated fiscal impact on state agencies is 0 in the adoption of stand your ground laws. Respectfully, I submit that that is wrong. Stand your ground places the burden of proof on the state. Unlike self-defense, which is an affirmative defense, where the defense attorneys and the defendant are required to prove that self-defense was necessary, stand your ground returns the burden of proof to the state. This has caused prosecutorial budgets in states where stand your ground laws are in play to be increased. Stand your ground in Florida and other states has removed the ability of law enforcement officers to arrest shooters when stand your ground self-defense claims are raised at the scene, because a prosecutorial determination must be made before the arrest. This increases the costs of not only the state's attorney's offices, but it also leads to an increased cost for law enforcement and increased danger for law enforcement officers. It costs states' attorneys' offices time and manpower to review these cases before issuing charges to determine whether the charges will withstand scrutiny during immunity hearings. For police, in cases where the charges are deemed valid, they must now track down shooters who are in the wind or gone to ground. This is costly in terms of manpower and dangerous because it causes the police to have to apprehend shooters who have already demonstrated the capacity to kill and their ownership of firearms. Prosecutors will now have to try a case twice, both at the immunity hearing and the final trial. The cost of trials are already crushing. Doubling them is going to cost Nebraska money. Senator Kintner is concerned about the cost of civil litigation facing shooters who are cleared of wrongdoing in self-defense cases, but the number of these potential cases is nowhere near the cost to Nebraska, both in terms of dollars and human capital. The state of Nebraska, its people, we cannot afford to foot the bill that Stand Your Ground creates. I ask you to consider the problems that we face as Nebraskans and realize that the need for Stand Your Ground when safe retreat is available is just not a problem that we face. Thank you.
Questions? Thank you very much for coming and your testimony.
Thank you.